All right, we'll gavel in the Public Safety Committee meeting shortly after, what does that say, 1:11. Introductions first, Ms. LaFrance.
Suzanne LaFrance.
John Wellington.
Brett Dyson.
Felix Rivera.
Eric Croft.
Forrest Dunbar.
Pete Peterson, Tim Steele.
Justin Dahl, APD.
Seneca Fino, City Prosecutor's Office.
We only had one item on the agenda today. The last 3 meetings have been so packed, and I've had to cut people off when I don't want to, or limit questions when I don't want to. Sometimes when I did want to, but that I intentionally set this as a little bit lighter on the agenda. The subject today is municipal prosecutions of felonies. Seneca will give us an overview on that. We have traditionally only prosecuted misdemeanors, that is, crimes that can be punished only up to a year. And she'll describe some of the challenges of that. That is, if we get something that is sent in as a misdemeanor, but we learn the facts that it should be charged as a felony, and that is typically in the municipal prosecuting world a repeat DUI offender. So at the third one, it can be a felony. And sometimes you don't know when you make the arrest what their priors are. So it can come in as a misdemeanor, and then you realize it's a felony DUI. Or domestic violence, where sort of the base level domestic violence is a misdemeanor, but can be a felony when it's particularly egregious, when there's strangulation or harm to the victim, and so it can come in as a misdemeanor, and then we try and send it over to the state. And again, previewing hers, but she'll describe some of the ordinary way the process should work is we get it, we send it over, they look at it on the merits, and they prosecute it if appropriate as a felony. We've been joined by Mr. Constant. And with budget cuts or for other reasons, that just hasn't been happening over this last year. So that's the context of that. And I wanted to get everyone sort of on the same page about what we're doing and not, what we could do, the limitations, the concerns of that. Did I steal all your thunder, Seneca? Yeah. No. I wanted, yeah. So I apologize if I did, but Ms. Thino, and then we'll have Chief Dahl's perspective on that, as well as whatever else he wants to update us on. I don't know that we'll need all the hour and a half, but we do tend to fill up whatever time we have. So Ms. Thino, to the extent I didn't steal it all.
Sure. So exactly as you said, right now, and for all of history, our office has been limited to prosecuting misdemeanors, which are those punishable by up to a year in jail. And those run the full gamut: theft, DUI, assault, stalking, pretty much all kind of behavior has a misdemeanor component to it. There is no legal prohibition on us prosecuting felonies. We simply don't have them in our criminal code, and so we don't. But if the Assembly chose to add them, then we could. And just to make that clear, we wouldn't be prosecuting state law, we wouldn't be prosecuting state felonies. We would add to our criminal code, to Title 8 or Title 9, that it is a felony to do X or Y or Z, and it's subject to felony penalties.
Eric, can I ask a question on that?
Yeah.
So Seneca, I don't know. So there's no. What you're saying is there's no state law prohibition, whether it's in the Constitution or statute, to prevent municipalities from creating felonies.
Yes, correct.
Do the felonies have to track with state level felonies, or could we create a felony that's, totally freestanding, an offense that's not prosecuted in the state, doesn't resemble a state?
Yes, because we're a home rule municipality, we have the full authority to implement anything that isn't specifically prohibited or limited by the state. The only limitation, or three limitations that are in place, one of which says that our driving code must be similar to the state's driving code. That's for consistency of movement. The other says that we can't implement something that is contradictory to the state. So if they specifically intended to legalize something, we can't make it illegal. And then under SB 91, we can't have a penalty that is greater than the state's for similar conduct. So if we did implement felonies and this felony was similar to the state felony, our penalty would have to be the same or lower.
Thank you, Mr. Chairman.
Yeah, it was somewhat of a surprise to me. I'd gotten so used to misdemeanors being municipal that I didn't realize it was more of a choice than written somewhere. So
Sure.
Go ahead.
So when our office we've talked probably for the last couple of years, just brainstormed this idea of whether we want to get into felony prosecution, or whether we want to ask you to help us get into felony prosecution. And there are a couple considerations there. The reasons that we would be interested in doing it, and I think these are good things for the Assembly to consider. The first is that we are beholden to the state to prosecute those offenses. And as Mr. Croft alluded to, we get a significant volume of what is felony conduct that is referred to our office as a misdemeanor. And in order to get it prosecuted as a felony, we have to ask the state to take it. And sometimes we beg, and sometimes we just gently ask. But in all circumstances, we are completely subject to their desire to prosecute. Over the past couple of years, their willingness to accept those cases has been on the decline. And there are probably lots of reasons for that. Budget, I would imagine, is a big one. There's some hesitation to take cases that they anticipate might be resolved at a misdemeanor level. So they could file it as a felony. They're not sure they'll get the felony conviction, so they say, why don't you just keep it? The problem with that, and the next reason why we would consider prosecuting felonies, is that leverage is an extremely important tool when you're talking about prosecution. And sometimes the reason you can get the misdemeanor conviction is precisely because you can leverage the felony charge against a person when that's in fact what they did. So reasons to do, again, we wouldn't be beholden to the state. We would be able to prosecute the felonies when they came to us. Sometimes those are known immediately. For example, with a theft, if the value of the theft was $1,500, that's a felony. You know it right off the bat. APD sent it to us by mistake. Others you learn later. The defendant was injured. The victim was injured. They went to the hospital. You find out later that they have broken bones, that they've suffered some kind of debilitation, long-standing, and so you learn after the fact that it should have been charged as a felony. We would be able to go ahead and just charge those under the correct sentencing scheme if we had felonies in our code. Again, it would give us that leverage that when someone has done that felony conduct, we can say, look, it's charged as a misdemeanor, but it does qualify as a felony. This is the deal. Take the deal, because if you don't, we will charge you with the felony. And then lastly, it's a good experience. There's no question that felony cases can be, not always, but can be more complex and can involve a lot more issues than a typical misdemeanor case can. And so for our lawyers who are excellent trial attorneys at the misdemeanor level, they would, I think, enjoy that opportunity to gain that experience prosecuting those felonies when it also had benefit to the city. There are some downsides, obviously, to engaging in felony prosecution, and the first and probably most obvious to you is a resource issue. It's a caseload of significant volume. That is because there's more at stake, so there tends to be more fighting. It's going to be an increase in the number of court hearings, an increase in the amount of motion practice. And it will require us to be practicing in two different courts, district court and superior court. So if we wanted to maintain our current prosecution at the misdemeanor level and add felonies onto it, we would in fact need to increase our numbers both with staff and prosecutors and to be able to do that. So that's a significant financial investment. Alternatively, we could do less emphasis on our misdemeanors. So we could prosecute felonies with our current case or current staffing levels, but we would have to let go of some of the misdemeanors that we prosecute. The downside to that is that no one else is doing them. The state has the ability to prosecute misdemeanors, but here in Anchorage, they by and large do not. So we are the only agency that's doing that. If we stopped, for example, prosecuting thefts under $500 or not taking other kinds of lower level cases, trespass cases, whatever, because we're doing the felonies, those cases go unresolved. I see questions. I'm going to pause there.
Yeah, do a round of questions and then we can do some more. I have Mr. Dunbar and then Mr. Dyson.
Thank you, Mr. Chairman. So a couple questions. First is, are there other municipalities in Alaska who have done this? And if not in Alaska, then are there other states who have similar legal constructions to ours where you've seen this done where municipalities are prosecuting municipal felonies?
So Excuse me. So Juneau is the only other municipality in Alaska that prosecutes consistently its own code. They do not do felonies. There are, outside of Alaska, other states where municipalities do. In fact, this last summer, I met an individual from a city in New Jersey, perhaps, where they do full felony prosecution at the at the municipal level, with an office of about the same size as ours, smaller population though.
And so and they haven't run into any kind of equal protection issues when it comes to, just trying to think here, you happen to live in a city that has these other laws. No, I think that's fine.
Well, and if I can just say that, keep in mind, we've been doing overlapping misdemeanor prosecution forever.
Right. And just to put an underline on it though, so you cannot, you prefer not to, or are you legally prohibited from prosecuting state felonies?
We don't have jurisdiction to prosecute state code.
Okay. All right.
Mr. Dyson.
Yeah, as usual, Mr. Dunbar is ahead of me. I want to be clear on what you said. I assume that the national pattern is that cities take care of all the crime in their areas, and so on and so forth. Did you infer that that's not true?
I don't know if that's true or not. I am aware of cities that do it, but whether that's the majority of them or not, I don't know. It's very common for counties to do it at the county level. We just don't have counties here.
But I assume New York or Los Angeles, those guys, their police forces do all the crime in their area. None of it's downloaded to the state, except in a rare exception where the crime's happening in many places.
I wouldn't know the specifics of the cities.
All right. And did you say that, I'm sorry, does Juneau prosecute felonies
Misdemeanors.
only? How about Fairbanks?
They don't prosecute at all.
They
So-
did at some point, right? Sorry to interrupt you. Fairbanks did have misdemeanor prosecution, and I don't know, I thought 20 years ago they, to save money, got rid of it and have the troopers and the state do it.
Do all the crime?
Yeah, they just got out of the business.
Well, Fred, you can have your police force, but the prosecutors be state. So they kept their police force, they got rid of their
No,
prosecutors.
yeah, I understood that.
Yeah.
But they do not have their own individual prosecutors prosecuting stuff like that. All right, thank you.
Mr. Weddleton?
So if we took this on, then the state could say, oh, good, and they cut another one of their people. Are we going to take it all on? Or, because otherwise, if we provide a couple and expect them to do the rest, where do you draw that line?
Sure. So that's a great question. That's an excellent segue into my last portion of my presentation, which is other things that we've considered. So obviously the easiest blanket thing is we just take them all, right? We say we're going to adopt the state code by reference and we put it in our code and off we go. I can tell you that makes us very nervous. Another option is to do limited felony prosecution, which is to say we are prosecuting these specific crimes. And we can either do that, for example, we're going to prosecute felony theft. That's a pretty simple one. It's the same as what we do, it's just a higher dollar amount. We could say we're going to prosecute recidivist assaults. So that was what Mr. Croft was talking about, where the defendant has assaulted and been convicted twice previously. The third one is automatically a felony, even if the injury level still is at the misdemeanor level. So we can say we're just going to add recidivist assaults to our code. We're going to say we can add just DUIs to our code. So we could pick and choose the things that we wanted to be in there. I think you're exactly right that if we did do a full spectrum addition to our code, that we would likely see the state shifting responsibility to us. And so I think it's important to keep that in mind when we decide how we want to expand. A couple other options that we've explored. One is to cross-designate one of our prosecutors as a district attorney so that we could charge out of our office on behalf of the state. And in that circumstance, we would be charging state code, state law. We tried to work that out with the DA's office a couple years ago, and it just couldn't come to fruition. There was a lot of ownership sense of that particular case and that particular, those charges, and the parties couldn't agree on how to make that work substantively. The other thing we could do is we could house a muni prosecutor over at the DA's office. We do this right now with the U.S. Attorney's Office for federal cases. So there is an assistant municipal prosecutor who's over at the U.S. Attorney's Office. They're deputized as a special assistant U.S. attorney, and they're responsible for prosecuting, Anchorage-focused crimes at the federal level. So that is another option, is instead of adding things to our code, we could take one of our prosecutors, stick them at the DA's office, have them deputized as an assistant district attorney, and say you're responsible for prosecuting the cases that the MOA wants to send over, the ones that should be prosecuted that are important to our office.
I'd heard about this federal cross-designation, but didn't know much more about it. So what kind of crimes are they doing? They're doing federal crimes, but with what focus?
A lot of gangs, drugs, weapons.
That we don't have the code for and wouldn't, yeah. So that kind of idea. It's not covered in our code, and it needs to be it is dangerous conduct, so it needs to be felony prosecuted or
Well,
federal
historically,
prosecuted.
like a felon in possession on the federal scheme is a pretty minor charge, but you can obviously understand very significant to the community. And so when we have our muni prosecutor over there, they're able to spend their time on those lesser cases that have a big impact.
Oh, so from a federal perspective, a lot of the stuff that looks important to us is not very important to them and might get dropped.
Yep.
Mr. Constant, did you have anything?
Yeah, it's more of a kind of a discussion that's on the topic you previously touched on. We can maybe come back to it, so I don't take away from where you are, because this is a pretty important topic, I think. And that was just the idea of reducing our misdemeanor crime punishment, whatever you want to call it, is not a great idea. And the more emails I get all the time are people mad because windows were broken on their car was rifled, and those becoming even less of a priority. Seems like it's going to cause more trouble for the city than not. So.
Mr. Weddleton.
I think I lost you at one point.
Okay.
My fault, not yours. But I think you had a couple options that we would take all felonies, or we would take some certain ones. And then the next way, I think I was unclear, was one is we put someone in the state group and the other one the federal.
No, one is that we could house someone in the DA's office.
A DA
Yep.
is state.
Yes, sorry, district attorney's office at the state level. So they actually get hired by the state, and their title is assistant district attorney, and they prosecute state law.
We pay for them and they housed there?
Yes.
Sorry, go ahead. Sure.
The alternative, the other thing I mentioned, was cross-designating one of our attorneys in our office. So the state can designate one of us. They can say, Seneca, you are now authorized to prosecute state law. I would do it out of my office, not theirs, and would do it in a very limited capacity. And that was the one that we tried to implement, and it kind of broke down.
Didn't under baggage say, I thought we had something like that going?
With the feds.
That's what that was?
Yes.
Okay. And you have not given us one. That's another option?
Well,
So
we're-
that's the housing them over at the DA's office.
We have one with the
Okay.
feds.
Yep.
It was a new DA.
Mr. Steele.
Yeah, I guess I'm missing something in terms of, are you advocating for something, or are you providing information?
I asked her to come here, and I don't think
Okay.
that there's any administrative position. She can speak for herself about the prosecutors, but it has come up that I wanted just to have everyone on the same page, so we all learn about it, and we think what we want to do. But I don't know of any administrative or mayoral position. Seneca, do you have a position?
Yeah, from my office, my folks are really, really interested in having the ability to prosecute felonies in the DV context. Those are the cases that hurt the most when we try and get the state to prosecute and they're not willing or able to. So the recidivist, domestic violence offenders, and potentially the strangulation cases that we prosecute as a misdemeanor that should be prosecuted as an assault 3. In terms of the other types of cases that our general trial unit, which are DUIs or thefts, so they're a little less excited about it. They have very, very large caseloads, and they're very concerned about our ability to manage that workload while still prosecuting misdemeanors. So it's kind of mixed.
Is there action necessary by the assembly in order to authorize you to do that, and are there budget considerations? And I guess we're the largest metropolitan area in the state, therefore it would be reasonable, we are a borough as well, so it would be reasonable that we took on something like this. The question is, what kind of pace do we do this?
Sure.
What steps do we take? What budget requirements?
Right. So if we were gonna start slow and easy, which would be desirable, then what we would do is I would draft up a code change to Title VIII that would just include penalties for, let's say, recidivist domestic violence assault. So we would draft the offense specifically so that it's covering domestic violence offenders on their third or subsequent. We would put in the penalty ranges that mirror the state's penalty ranges for that offense. And then we bring it to you. If you approved it and put it in the code, then we would have jurisdiction immediately. At that level, doing just that recidivist type of prosecution, I think we could do it without having any budget considerations at all. I think we would be able to maintain, certainly on the general side, our current caseload, and I think on the DV side, probably pretty close to our current caseload. If we expand anything beyond that, then I think we start getting into, we either have to accept that we're going to prosecute less, or we have to look at budget increases.
I guess I would like to, we've got issues, the state's got issues. The state's budget is not going to get much better unless they do something drastic, which I don't see political desire to do it, although I think it should, personally. So I think we need to get into it, and we ought to ease into it and see where we go from there. And that's my one man's opinion.
There we go. I have three people in the line, but I put myself in the queue as well. So Seneca, you made and I looked at some examples of. Are you comfortable with this out, or would you like to scrub it one more time?
I would, if you want to release it, I would scrub it first.
Do you want to just talk about? I asked Seneca to ask her prosecutors for examples of things that were sent up as a felony and rejected, and she did that. Would you feel more comfortable just describing a couple, or?
Yeah, I can do that.
Okay.
We had a felony DUI. It was actually a repeat felony DUI where the defendant had gotten into a collision and ran back to his house. Officers contacted him very shortly thereafter and weren't able to do a full DUI investigation. They weren't able to get a breath sample from him, but they had witness statements that he was intoxicated. He was acting very intoxicated, had crashed his vehicle, and we attempted to refer it to the state because it was in fact a second felony, and they rejected it and said you don't have enough evidence. We took it to trial and won. Very quick jury verdict on that one.
But it was prosecuted as a misdemeanor when it was already a second felony.
Yes. So his minimum, I believe, was 2 to 5 years in jail, was what he would have been facing at the felony level, I believe. We had a circumstance where a woman was kidnapped. She had gotten into a fight with her ex-boyfriend, had tried to walk away. He grabbed her, he threw her in his car, he employed the child lock so she couldn't get out. When she tried to climb out a window, he grabbed her and pulled her back in. She eventually was able to get out. She ran to a neighbor for help. He dragged her by her hair and throat back to the car, put her back in, drove off again, beat her up in the vehicle, told her he was going to kill her, choked her repeatedly, and we got that case as a misdemeanor. We tried to send it to the state as a felony, and we were told those are hard to prosecute, and that was the end of that. We had another individual whose boyfriend had taken her out to play Warren's-Off and choked her repeatedly until she couldn't breathe. She thought she was going to die. We also told her that he could kill her. We asked the state to take that as a felony, and they refused. They didn't think that they'd be able to get the felony conviction, so they didn't want it. We had another individual who suffered serious physical injury, was choked, punched in the head 6 times, and kicked repeatedly until she fell off a bus. She had concussion at the time and suffered some long-term debilitating circumstances, dizziness, fatigue, inability to sleep, inability to see. met the definition of serious physical injury, asked the state to take it, they declined. So that's just a quick survey of some ones that stick out to us.
I have a number of people. I'll put myself back on the queue afterwards. So I have Mr. Dunbar.
Thank you, Mr. Chairman. So I know you said that you think you could do this limited class of cases without additional resources, but I am worried about what John has raised. I think that if it were just the cases we're doing now, that's probably the case, but I'm worried about the state then being, oh, you'll take the, and then start shifting even more and more our way. The other thing I'm curious about is, we've raised before the prospect of our defense contract. So we have a firm that we pay to do our defense work. If we start doing felonies, are they going to come back and ask us for a change in the contract? Is their contract allow them to defend felonies?
The contract does not cover felony prosecution. The contract covers only misdemeanors.
So how would that work? Would the cases go to the state public defender, or would we have to pass create a new contract for felony?
Yeah, so that's an excellent point, and I apologize. That would be the one budget consideration, is that we would have to do a separate contract with either Denali Law Group for the felony prosecution, or we would contract with the Public Defender's Office to do that.
Yeah, you're
Yeah,
actually next, Mr. Constant.
Perfect segue then. You gave three options that I see. One is that we take it on, create a new section of code. One is that we plant someone at the DA's office, and one is the DA deputizes one of ours. And we tried the DA deputizing one of ours, and we've heard concerns about what happens if we start taking these on and we start doing all of them for the state. That middle consideration of sending someone to the DA's office might in fact avoid that requirement, because if we have someone implementing state law and they're in the office, make the argument, hey, we're going to take this because this is blatant, then the state the state public defender's office is still on that case because it's in their hands, and we create some protection. And in fact, that will help us keep the state doing their job and not pushing onto us if we go down that road, because we can have someone in the room when the deliberations are being made on how cases are being taken. And we can have leverage in that conversation and maybe be able to make a more rational case for them why case A or case B might actually be something the state should take on. So it seems to me that's the most reasonable path. But we need more information, obviously.
I have Mr. Peterson and Mr. Weddleton, but sort of on that, I know, Seneca, we have an expertise in domestic violence prosecution. We have 3 dedicated prosecutors? 4. Does the state have a dedicated prosecutor for DV?
Yep.
So they take them on. Interesting.
The DA's office used to be arranged by subject matter.
Right.
So they had a violent unit that would handle assault ones and attempted homicides, etc. They had a sexual assault unit, which would end up getting some DVs, of course, because there's oftentimes a sexual assault component. Then they had a misdemeanor unit, they had a theft unit, and a drug unit. They switched that up, and so now they're assigned by judge rather than specialty area. So there's no specialization in the office at all.
And then we have 2 officers that are serving warrants for us in the
They're doing compliance checks for us,
Is that mainly domestic violence, or
exclusively domestic violence.
and the state doesn't have a similar?
Nope.
So that's an argument for why we would stay in our lane, if you will, our domestic violence. We know it well, we have the tools for it, and we just up our ability to go sort of those more. Yeah, so Mr. Peterson and Mr. Weddleton.
Thank you, Mr. Chairman. So if we decide to take on these local domestic violence cases and prosecute them, is that going to put us in a situation where we have to take and decide not to prosecute some misdemeanor cases because we don't have the personnel to do that?
If we took on just the recidivist domestic violence assault cases, I think we can do that while maintaining the majority of our current caseload. There would be some adjustment, but it would be on the DV cases only, and it would be the lowest level, and I don't think it would be significant. If we went beyond that and took on anything else, DUIs, for example, or other types of assaults, then yes, we would not be able to maintain our current prosecution rates with our current staffing with those felonies.
Great. Thank you.
Just there, and then I'll go back down the list. But explain to us why important to have that felony prosecution ability. That is, it's not just I could have gotten them a year and now I can get them on 2 years. There's a different probation.
They have probation officers, which you don't have in misdemeanor land at all. A lot of people don't realize that misdemeanor probation is unsupervised. All it means
Which
is
really
that-
just a suspended sentence, or a portion of the sentence that you can come back in and take.
If we happen to find out that you have reoffended or violated your probation, then we can petition the court to impose some part of the sentence that was suspended, so some jail time or some fine. It's all paperwork. So this image of probation officers coming and taking you from your house and you go back to jail, that does not happen at the misdemeanor level. We file paperwork. If you're convicted of a felony, then there are lots of implications beyond just your sentence, of course, but you do have a probation officer and you are subject to arrest for your probation violations.
So I'll go back down the list, but then who would do that if we did our own code? How do we have, we don't have probation officers, so where do we?
DOC does probation.
Even if we did our code? Interesting, okay. I had, Mr. Weddleton and then Mr. Dunbar.
Thanks. So you gave us some examples of some cases that you would have had prosecuted as a felony and the state sent it back, and their reason was because they didn't think they could get a conviction. And I mean, maybe you would find the same thing. I mean, you haven't been doing them, so if you start getting involved with this, these seem pretty clear that you want something to happen, but in these cases,
Sure,
I mean,
so-
maybe they're smart, they have experience with it, and you would end up the same place.
That is always a possibility. In every one of those cases, we got convictions at the misdemeanor level. And the only difference between us and them is that we have 6 jurors and they have 12. 12 people is harder to convince, of course, than 6 people. But I think that's persuasive. We've also heard, and I don't have this in writing, no one is going to say this to me directly, but we hear lots of things about that the district attorneys are instructed not to take cases unless they are slam dunks. Don't take a case unless you know you can win it as a felony. If you're only taking a case that you know you can win at the highest level, you're obviously not going to be taking nearly as many cases as you possibly could. I think we're more willing to go out on a limb than they are. But what we also see are the sentences that are being imposed, whether on a felony or on a misdemeanor at the state level. And we're seeing those as being lesser sentences than what we're obtaining at the misdemeanor level here. So there's a pattern of behavior that we're privy to that suggests it's something more than just they have better insight than we do.
Okay, good. Thank you.
Seneca's walking a very fine line, doing it beautifully, but I mean, the DAs are their partners, as are the federal U.S. attorneys, and they do a lot of work together. And so you don't want to be overly critical, but if they've been noticing that things that used to be prosecuted aren't anymore, and things that they think should be aren't, it's sort of, we're trying both to raise the issue without losing that relationship. Mr. Dunbar.
Yeah, and just to add on to that, I mean, the state DAs are facing incredible pressures right now, budgetary, in their budget. So these are horrific cases, and they've turned it down. But if you look at the cases the DA was actually prosecuting, some of them would blow your mind, in how terrible they are. And so they're making unfortunate, but from their perspective, I think sometimes logical decisions. But until the state legislature decides to properly fund public safety in the state, here we are. Anyway, but what I wanted to ask you about, Seneca, is so if we were to go down this road and we'd have to write a section of the code dealing with domestic violence and adopt it at the municipal level, and you talk about the municipal prosecutor targeting recidivists, but am I wrong that, so I don't know that section of the code sort of off the top of my head, is it possible to, would we be able to write, the city has now a felony offense for recidivists, or would you have to have the underlying code as well? That is to say, some other kind of felony beneath that maybe you would decide through prosecutorial discretion you weren't going to charge, but you have to have some underlying code that they would offend several times before they got there.
Right, so we have that.
That's just
our
the
current
misdemeanors?
assault code.
So,
Yep.
so we could do a very narrow, targeted, it is a felony in Anchorage if this is your third or more, or whatever the code is. And
Exactly.
just past that one
Yes.
line of code or what
Yep.
what have you.
Yep.
Okay.
And we would reference, if you've been previously convicted 2 or more times of assault, domestic violence assault under this code or similar code from another jurisdiction.
And could we, I'm sorry, Mr. Chairman.
Keep going, no, that's cool.
Can we just lift, so my preference would be that our code look as much like the state code as possible and hopefully identical. And could we do that? Could we lift just that section of code and put it in ours?
Yes.
Okay. Because I don't want there to be forum shopping for prosecutors either, right? That is, well, we have a slightly higher penalty or we have a slightly different code, and so it'd be easier to, that's not what we're talking about here, right?
That's not what we're talking about here. I would enjoy
Right.
debating with you the benefits of
Yeah, I
having
know.
differences in codes at some point, but no, here we're just talking about what does the state have that we don't have? Are there benefits to us having that specific thing?
Yeah. Okay. All right. Thank you, Mr. Chairman.
Mr. Steele.
Yeah, I guess I'd like to hear from the chief in terms of, you know, you have to enforce things. And do you see some areas where you would like to see us having greater enforcement because it would act as a deterrent in terms of various things? Do you have an opinion one way or another on which way we go with regards to this?
Well, this is something we talked about just a little bit earlier, but I think from the police department's perspective, we worked various cases, we package them together, and we hand it to a prosecutor. So in some respects, it's kind of transparent. We don't really care which prosecutor we hand it to. We do our part the same no matter what. But I think that having the ability to have some additional options is beneficial, because what's very frustrating for any police officer or detective is to put a lot of work into a case, package it up, hand it off, and have it get thrown away. So if the city has some capacity to prosecute some of these cases ourselves, I think from the police department's perspective, that's advantageous, and it also gives us maybe a little bit more control over our destiny, because now we can identify things that are a priority inside Anchorage, and those can be sort of highlighted for prosecution, where maybe at the state level they're having a little bit broader perspective, and maybe that's not the thing that they're focused on, so we can kind of set our own priorities. But you know, I'll also throw out there, and Mr. Croft mentioned it, but the Anchorage Police Department has a great relationship with the Anchorage District Attorney's Office. We work very closely with them, and that partnership is very, very strong. So it would not be because that doesn't work for us for some reason, but it just gives us different options and different abilities. And police officers always like to have another tool on the tool belt. So.
No frustration in terms of particular cases or particular crimes that that you feel we have.
Police officers think that every arrest they make should be prosecuted all the way to the end of the conviction. So is there frustration there? Yeah, but that's the nature of that. And I think that there should be some natural balance there probably.
Yeah, none of this is intended as a criticism of the district attorney's
No.
office personnel. Yeah, in the same way when we talk about snow plowing that Mr. Dyson was talking about, other areas where the state budget cuts have affected us, it's not really that the individual state employees are doing any worse of a job. It's just there aren't the resources there and things are getting dropped. Mr. Gates, did you have something you wanted to say?
Yes, I was wondering, you mentioned a few times potential budgeting talks, particularly felony prosecutions, and I just wondered if the cost of incarceration is rather impact if we successfully prosecute a code-based felony and then the person goes to prison for 4 years. Does the municipality get billed by the state's Department of Corrections for that incarceration? Is that something we have to consider?
We have a contract with Department of Corrections that covers, I believe the way it's written, it covers anybody staying there, but it's a certain amount per year. But yes, I have no doubt that DOC would want to renegotiate that contract if we were putting people away for years at a time, consistently. Just to clarify, we We do sentence people to multiple years in jail when they have multiple cases they're being sentenced on. So it's not unheard of to have one of our defendants in jail for 2 or 3 years, but it would be more frequent.
Yeah, Pete, sorry, Mr. Peters.
Thank you, Mr. Chairman. So, so we are putting these people that we're prosecuting, if they're found guilty, we're putting them in the state prison system. What about the Anchorage, the local Anchorage jail? How long of a sentence do they get? Do they get to stay in that jail at all, or is that all pre-trial?
Right, no, it's all state-owned. All the jails are state
Okay.
facilities, so we use them now and house our folks there.
Right, so, I mean, so the Anchorage jail's actually, we pay $1 million a year or something to use that jail or something, as I recall. So, okay.
Using a quarter.
All right, thank you.
I mean, I think one of the ways to look at this is beyond the current state budget problems. That is, it might not be appropriate to step in if they're just cutting and we're just stepping in, sort of where does that end and how do you do that? If there were a good long-term reason, that is, even if the state got its stuff together and you say, hey, this, even when you're doing appropriately, because of our expertise, because of how many DV prosecutions we do, having this sort of vertical ability to go up another notch may make long-term sense. I think everybody, well, I know I and a lot of other assembly members I've talked to are worried about just stepping in where the state isn't doing a good job, that that's not a good long-term fix.
Mr. Chair, on that issue.
Yeah, Mr. Dyson.
I would suspect, I think there's at least 2 national organizations for people like us, you know, either county or city sorts of things. I think it'd be worthwhile of inquiring of them what is kind of the distribution of this in cities in the country, and are there other jurisdictions that have gone down that road and worked through these issues that we might be able to learn from them.
What are we members of? Yeah, there's a National League of
NASCO,
Cities.
NACO.
Okay, but yeah, I'll see if they have any. Yeah.
And there's one on counties,
Yeah, that's.
and you know, we're kind of a combination of those 2. Thank you.
Yeah, Mr. Dunbar.
Seneca, would you be able to, and I'm sure Mr. Kropp would ask this, could you give us, first of all, I'd be interested in seeing exactly what the revision of code looks like, because I think I want to echo what Mr. Kropp is saying. I think that it's true, we don't want to turn Anchorage into sort of a state within a state, right? Because the state of Alaska is falling down on the job. But there are certain things that perhaps over the long term we could do well, and I think domestic violence is something that I know that everybody on this body really cares about, and it's a huge issue in our community, and if we have the expertise to do it, then that makes some sense to me. But I would also like you to prepare, in addition to that, sort of 3 scenarios, like a best case, middle road, and worst case scenario in terms of budget impact on us, if you could do that. So how much are we talking about if we have to significantly we have to do a new defense contract and they really hold out? If we have to perhaps add some resources at your office and the state demands that we renegotiate our jail contract, and any other costs that you anticipate. What is that range of costs that we're talking about? Because I think that's going to be a major factor for us.
Mr. Constant.
I'd just add to that second option as well, maybe an investigation of how that might roll out, what the benefits and threats of that might be as well. That's the option of us planting someone at the DA's office so that we have someone in their process, and could be both.
So there's some money coming in, right? If we did our own code, we get fines and penalty. It just depends on how much we're collecting on those. And how much of a difference it is between what we'd get on the misdemeanor level and what we'd get in the
Right,
felony.
so for some things, for example, DUIs, there are minimum fines. They're pretty substantial. For assault, there's no minimum fine, but the fine ranges up to $100,000 as compared to up to $10,000.
But this, I'm sorry,
Go
does
ahead,
that
yeah.
go to the victim or to us? And
The fines go to us.
Oh, wow.
Yeah.
Hold on, it's getting order. DOC, the possible defense costs, the direct cost of us prosecuting. Is there a third category?
Jail.
Yeah, DOC, jail.
Oh, sorry, yeah, defense, us, jail, yeah.
Okay. Who wanted?
No, I'm good.
Okay. Was there anyone in the audience who came here to testify on this issue or generally? Or you're here to listen and learn? Judge Rhodes. So I wanted to make sure we got that. So let's take a break for a second, and you and then anybody else who'd like to.
I've actually come on a separate issue, but I certainly have something I would like to say about this one. But I don't want to cut into however long I have to testify today, so.
Well, tell us anything you think would be helpful. We did, as I said at the beginning, I think we'll have time today. We haven't for the last couple, but I think we have time today. So,
Point
we,
of order.
yeah.
This is when I called in when I was in Bozeman,
Yeah.
I could hear everybody here, but when speakers spoke, it got very faint. So
you wanna
I would
come on up?
suggest that they come up closer to the mic. So we have
I can usually hear Judge Rhodes fine, but
Oh, for the
we'll see.
recorder.
Just listening, first of all, thank you for the respectful use of my title. I'm not here as a judge, I'm now retired, so I do have a little more time to spend on my community, which I care so very greatly about. And I did, however, have a past where much of this was part of my life, and it's nice to see Ms. Thino again. Through the chair, of course, first of all, any prosecution, there's an ethical requirement on the district attorney to assure themselves when they review police reports and investigatory materials that the burden of proof beyond a reasonable doubt is met before you prosecute a case. It's not just a question of whether you think you can win at trial. It is subjecting anyone to a prosecution wherein they have months and months of litigious things in front of them, including hiring their own attorney and all of those things that disadvantage a person in a prosecution. So I just want to say that no matter who you are, any prosecutor has this ethical burden. So I think it is, one does need to be careful when it looks at other prosecutorial entities with an eye toward wondering why they have refused a prosecution. The second thing is that the state's been defunded, of course, and that is why some prosecutors have been cut. But the other significant thing that happened was the state took on criminal justice reform, SB 91, and there's certainly been backlash issues about that. SB 54, I believe it is now, has been passed. We're going to see that roll out along with the SB 91 things. So some of the things here that you're considering, you probably want to look at these within the context of those things, because the Department of Law now has a public safety action plan just released at the last Criminal Justice Commission meeting. The governor's budget does place prosecutors back into the mix because the state has recognized that it's failing the municipality and other locations rurally and in the entire state. So I think that doing things in a vacuum is always a problem. Look at what the state is looking at in terms of what it perceives to be some of its shortfalls and how it's redirected and recorrected the criminal reform business that it's engaged in. The next thing is that with respect to changing the municipal code, you will have a jail contract change. You can't put people in jail for 5 years at a clip and expect you're still going to pay the Department of Corrections, which is a unified system. Your Anchorage jail is the state Department of Corrections. You're not going to pay the same thing if you start doing felony prosecutions under the municipal code. You are not going to get probation supervision under the municipal code. Look at Title 25. I cannot believe that the state of Alaska would agree to probate people using state resources on a municipal code felony violation. And probation and community corrections is very expensive work. Using technology, electronic monitoring, lots of different things, because now jail classifications actually include things like electronic monitoring. So you'd be getting into a whole nother business. Denali Law Group, your contract there would clearly go up. Felony prosecutions are big, and they are not handled the way that high volume misdemeanor traffic is handled in terms of the way they're defended or the way they're prosecuted. And state prosecutors, they would also be spending much more resources doing felony trial work. I've done both. I can tell you that a jury of 12 people, all you need is one person to decide that they're not going to convict. And so when you look at some of these cases, you can see why the state may have declined them if they have a different situation and culture and discovery process and everything else in which they are going to try these cases. It is just a very different picture when you're looking at felony prosecutions. For these reasons, I say Mr. Constant's suggestion is really probably the one that's worth looking at the most, if you're going to look at any at all, which is to you stay under the state code, you stay under the state budget, you stay within the state parameters, you do one carve out for a particular area of crime that you think is important and not every area of crime. And you try to work with the state under their new public safety action plan, which specifically calls for collaborations with municipalities and rural areas, tribal courts and other things. The state recognizes it can't do everything anymore either. So this is a beautiful new culture to have this conversation in. Get somebody within the district attorney's office to do a particular carve out, decide what your carve out is in terms of what your public safety data is. The other thing I'd suggest you look at is how many cases go to trial which are actually acquittals. And while you talk about, yes, you had one good win there on a misdemeanor case that might have been prosecuted as a felony, I can tell you that looking at the data numbers in the court system when I was working on that stuff, the pretrial delay is enormous, and there are a much higher percentage of cases acquitted than you'd like to see if the ethical standard of charging is beyond a reasonable doubt. Thank you so much.
Anyone else interested in sharing their views, testifying?
Are we gonna have that other conversation?
Which?
So, Ms. Rhodes actually came to speak on a different matter, and I think if we have a few minutes, it's worthy of just opening the can for a minute and getting that on the record.
Okay.
Oh, so we're wrapping up this.
Yeah, I want to spend a little more time on this, and then we can have people share on any matter of public safety, or really anything they want. What is the sense of the committee as a whole? What do you want to do on this issue? Forrest talked about having Seneca give us options. How do you want me to bring this back?
Well, thank you, Mr. Chairman. I think because of limited resources, I think we have to look at this realistically, and I think Mr. Constant's idea of entering this in a limited form of way might actually be the way to start out, and then if that works well, maybe we can add on additional prosecutors or whatever's necessary at a later time. But start out kind of at a minimum level, and then go from there. I don't know. What do you think?
Seneca, what's the practical difference between a deputized municipal prosecutor who can now do state felonies living in your office, working, or in the state's office? What difference does that make?
Difference in terms of benefit to us?
They're still paid by us, and they're still prosecuting state law. Is it just who gets to tell them what case to do? If they're sitting in your office, you can tell them to do the cases you want?
If it's a person that stays in our office that's just cross-designated, then they are still working their municipal caseload. They have the ability to indict when they think it's appropriate or necessary. If we house the person over there, then we're taking a body from our office, or we're getting a new body, and we're sticking them in that office, and they essentially become, for all intents and purposes, an employee of the district attorney's office.
Who tells them which cases to do or not, whereas if they're in your office, you're telling them which cases to do or not.
Yeah, so the expectation, if we paid to house someone in the DA's office, there would be an MOU with expectations clearly outlined about what cases those people would be doing. They would be, either ones that were referred by our office or ones that were targeting an issue that our office had identified. Or however we wanted to work that out, we would specify in the MOU. The DA's office certainly, because it would be working in their office and filing under their name, would have an interest in what those cases are. But the objectives of the position will be clearly outlined. If they were cross-designated and housed in our office, then yes, the primary direction would be coming from us, which is probably one of the reasons that makes them a little more nervous.
Mr. Dunbar?
Thank you, Mr. Chairman. Just a follow-up to that. So you said that something like this had been tried and it fell apart.
Mm-hmm.
Was it the deputized, or was it the person over there?
The deputized.
Was it deputized? Okay. And then when it fell apart and the last time we did this, was that, I assume it wasn't under Rick Allen?
No,
Was it
correct.
Clint Campion or someone before Clint Campion?
It was both with Clint and prior to Clint.
Okay.
Yeah.
And I'm not casting aspersions on Clint or what have you, or I guess Major Campion as I know him. Okay. Do you need any assistance from us in terms of reaching out to the DA to Rick or to?
No, I have a meeting with Mr. Allen next week.
Okay.
And this is going to be one of the topics that we're discussing. We have a lot of arrangements between our offices and how we handle cases together, and so I want to go over those with him, and then also sort of open the door as to this one and see kind of where he falls as well.
Okay, thank you, Mr. Chairman.
Mr. Dyson?
Thank you, Mr. Chair. So you asked for direction. I came here thinking we were going to approach this on kind of a global level, but I think you're starting exactly at the right spot. So when a person is arrested on a misdemeanor thing and in the investigation they find out it's felony, I think absolutely we should continue on this. And particularly when it's on personal injury, personal assault things, domestic violence, other kinds of things. Mr. Constantine raises the question. Most of the calls I get about property crimes, and all of us care about that, but when it's an assault on a person, and we as a state lead the nation by orders of magnitude, both domestic violence and other kinds of things, I absolutely want us to be able to make that amongst the highest priority of the stuff we're going at. So I commend you on that. And that's my advice. I don't even think I'm a member of this committee. I don't remember.
It's a committee of the whole. We're all members, yeah.
All right, that we ought to proceed. And I appreciate both the information and the attitude that you appear to bring to this. Very credible.
Mr. Constant?
Yeah, just to reiterate, I didn't come up with this idea. This was her idea. That Ms. Dana's idea, and I support it. So I just don't want to take credit for something good that someone else did the hard work for. And I think one of the key elements to explore really is what benefit your office might have having a seat at the table when decisions are being made in the state prosecutor's office. And I think that's almost an unquantifiable benefit in terms of the value you could get out of that. If you have the right person, a diplomat that's also a good trial attorney, that way, we help shape the state's local priority. And I think there's a huge value there. So.
The federal example has worked well for how long now?
Probably almost 10 years now.
Any other questions, comments on this issue? Appreciate it, Ms. Thino. So maybe what I'm hearing is the very narrow municipal law, even though there's some good points about why that might not be the way to go, and then keep us posted on your discussions with the DA about whether there's a chance to do either the deputized in ours or the deputized in theirs.
Yes, and I will also look at sort of some budget summaries, and I will bring those to you.
Appreciate it. Public comments on any issue then. Do you want a second bite at the apple, Judge Rhodes?
Well, actually, I'd asked for an agenda item, so if it's not going to be an agenda item, then yes.
Or how about I can put it, what agenda item do you want me to add to the next or a subsequent meeting?
Fire code changes.
Yeah, rather than doing that in the fly, I'll add that to the list, and once you send me what you want on it. I know we did talk about it before in terms of homeless camps. Is that still the concern?
It's still the concern.
So you sent an email that I think we have a draft ordinance that was circulated, and we went around and round on how to come up with language that would actually achieve constitutionally some level of change in how our fire policy in the parks is going. And I think in a moment of passion, maybe you wrote an email late that I think actually has the language we need. And it was specifically that there needs to be a law change clarification that completely prohibits fires, heaters, grills, propane, etc. from all municipal property without a permit for one-time recreational use in permissible designated areas. And so that snip of a sentence right there might actually be the piece that we were missing from the draft ordinance that we couldn't quite figure out how to
I
frame.
can put that in context now if you would like.
So you can come back and do it or not, but I just want to get those words on the record for that.
I think I'd like to have you back. We did, as he said, sort of went one round on it. So for the committee, but we can have that as a full discussion, bringing it back. There was sort of the 15-day to 10-day clean ordinance, if you will, and then a lot of the other concerns about homeless camps that have been expressed, fires being a big one from your and other examples. You're supposed to get a permit to grill things in parks. I don't think many people do.
Unless.
Well, and so if we mean Joe with a can of lighter fluid cooking hot dogs, and if they don't have a permit, we're going to really sanction them. If we mean that, then we need to do it uniformly.
Well, sorry, Mr. Chairman.
Well, hold on. So, Mr. Steele.
Yeah, if it's in a facility, if it's in a barbecue pit.
He just
or a
read
fire
language
pit.
that said from all municipal property.
Except in a place where it's permitted, which is and one time. That was the key language that we never got to.
The permits, or you can go in and get those, but my impression is that most people don't.
Well, I just, you probably remember 2 weeks ago, I wrote an exception for community councils, so they would be
Yeah.
accepted from certain parts of the code. And I would have the same sort of thing. If you're in an actual barbecue pit,
Yeah.
I would want I wouldn't want you to have to go and get a permit from the city.
And the key was the
regardless of
one time, right?
Yeah, yeah, yeah.
One time.
One
so
time
because
in
the
those-
fear was that would become, they would come and camp at where the barbecue grills are.
So you sent
Yeah.
that email to me and everybody else?
I
I
forwarded it
think
to
it
you.
would be helpful if I could put 5 minutes in context, because I know the
Please.
chief came today, and
But
so
this is
I
easy.
think for you to understand the problem,
That's what the
then
language
you can
is.
certainly put it over, but, we've come prepared to look at it today, so it would be fair.
I want people to-
Chief, you're prepared to talk about fire code changes?
That's good.
Well, come on up. It's not noticed, but as I said, I did this a little late, so I don't think we can take any action, nor do we really have any action before us to
I
take. But
think that's fine, but I think it gives you the idea of what the problems are.
Yep.
So again, I'm Stephanie Rhodes, and what I want to show you is I testified here some time ago about fires on the Chester Creek Trail. There was a fire, you'll recall, that was in a tent, big encampment, and the fire department responded, and they analyzed it as a residential fire with according to the code as to whether it did or didn't, whether it was or wasn't on a concrete pad, whether it did or didn't have a thing that vented it. And, when we came here, the analysis that Mr. Falvey gave us, and also, others, was that no, under AMC 25, that all fires are prohibited. So it came as a surprise to me that on 12/14, that very camp was actually moved down some feet on the Chester Creek Trail and completely burned to the ground. There's the photos. And then on 12/25, Christmas, we were coming home from a movie, and at 16th and C, same general area, we called the fire department on a wood fire. And the fire was pretty substantial in our way of thinking. And the incident report that we received said, bystanders directed us to a fire, stated this happens. The responsible party, my husband, said, the responsible party, the person who was burning, said, it's my legal right, I'm homeless and I live here, I'm just going to light it again after you guys leave. And the disposition here was that BO2 informed the responsible party that although one can burn in the municipality, his fire did not meet the limitations such as being at least 25 feet from trees, brush, and dry grass, clear an area on the ground of at least 6 feet in diameter, and to have a charged water hose within reach of the fire and a tool such as a shovel to extinguish the fire when done. He was also burning sleeping bags, shoes, and other trash and debris. ABD informed of the situation because he was combative. So this is, in my estimation, according to any law you have, a wrong legal analysis. And maybe I'm wrong, and you can correct me. However, it appears to me that on the Chester Creek Trail, you simply aren't allowed to have fires. And if you are, then this is a danger to our communities. We live here on the Chester Creek Trail. So the last time the AFD report analyzed the contact as under the residential fire code as to whether you can or can't have an active live heater in an encampment, just like you'd have at home. This time they've analyzed the fire under what appears to be open fire, the burns that any one of us would have in our backyard. But I don't think that's a proper analysis on a public safety level when people are living across the street from this fire. And so there's the rub. So I'm not sure what needs to be changed, but I will tell you that there should be no circumstance in the community's view under which anyone who is basically squatting on those premises, which are municipally owned lands, should be able to have any kind of fire whatsoever, an open flame of any kind, where it could affect residents. The Skirtwell fire was started by a homeless cook fire. And this is the harm that we fear. And this is not the first time that we've had this fear or that it's been justified. So I ask this assembly to kindly review fire laws with respect to the municipal areas such as the Chester Creek Trail. And I know that the fire captain has come with an interesting decision tree, which we can hear more about, but there's got to be some kind of enforcement here that is absolute and that requires no fires whatsoever to impact the community and the residences around there.
Good, thank you. Again,
I'm going to leave these for your records,
thank you.
along with the fire report.
Did you want to respond, Mr. Fire Chief?
The only thing I would suggest, we actually have a meeting later today to discuss this within the leadership of the municipality. But in every case, when we're dispatched to a fire on municipal land, we extinguish the fire. In every single case. I think there has been some confusion at the station level because there are areas where the responding firefighters don't know whose property it is. It's a wooded area. Is it a commercial wooded area? Is it a municipal wooded area? And what they try to do is they educate. And there's 2 to 3 explanations of when you can and when you can't have a fire. And I think our captains have sort of bundled those conversations together. And it's been confusing to people. The short answer is no. You cannot burn in municipal property whatsoever. You cannot have a slash pile in your own property. You cannot burn garbage. Burn barrels are not allowed. I think the law in a municipal code is pretty clear. You can't do these things. I'll have to apologize for within the department. We've had, I think, some captains who are trying to broadly educate on the whole universe of fire versus saying to the roads when they were there, no, this is illegal. But beyond that, we don't have any capacity or authority to do anything. Even within our contract with IAFF, Article 18, we do not do any police enforcement action whatsoever, except for the fire prevention. So when these captains and these crews respond, the only thing they can do is put the fire out. And then they leave. But they should know that without hesitation, and in all cases, there's no debate. Those fires are not authorized, they're not approved, and they need to be extinguished.
And you've
What
worked
happens
that through
beyond
the chain of command. You've resolved those sort of communication
I thought we
issues.
had.
Yeah.
But we have reinforced that message again this week.
Yeah, Mr. Steele.
Yeah, I'm thinking about Valley of the Moon Park or Kincaid. Are there any barbecue facilities? And the pad, like the pad at Valley of the Moon, do you have to reserve that, or does it first come, first serve? And can they on that pad bring a barbecue, a hibachi or a small barbecue to cook food? And I guess those are the issues that stretch the imagination to a certain extent.
Let me just read the one sentence code language that exists already, and we'll see if there's any confusion. 2570060, I think that is, at subsection O, no person shall light, build, use, or maintain an open fire or portable camp stove within a park except in a receptacle or an area designated for such use by the director.
Okay.
So when you go into a park and it has a protected area and there's a grill there and you want to grill your family hot dogs, you may do that.
Sure.
And then it continues,
long as it's
No
not
person shall leave an
instantly
open fire or portable camp stove unattended. Makes a lot of sense. No person shall use flammable liquid other than charcoal lighting fluid to start or accelerate a fire. But if you comply with that, absolutely, you can have a picnic in the park.
Mr. Reynolds is next. I mean, we can bring that bill back before the committee and discuss it. It had sort of the miscellaneous elements that had come up from the discussion that started with the 15-day to 10-day, but issues such as when you could clear quicker, what an emergency situation is, what storage you would have to do if you stored, whether you could just get rid of them if they were a certain proximity to protected uses like schools and other things, and this and the fire issue as well.
Wasn't that a separate one?
Yeah, no, we
The
pulled
fire
it.
one?
Oh, I thought it was
I
all
thought
in
we
the same
pulled
bill.
the fire one out. Mr. Trainee had like guns and explosives. Like
Was he for him or against him?
well, he
usually
was
for him.
against propane tanks being in the parks because of their potential to be used as improvised explosive devices. And so I just remember there was a separate item for that specifically. And I think
My
this
recollection was
falls-
all one bill, but I can check. Mr. Reynolds?
Well, just on that, I mean, my gut feeling is separate these two issues. It sounds like we have the rules in place now, so you can't have those fires.
Yeah.
That sounds pretty well supported. The question is, so
What do we do about it?
Rhodes and others would call the fire department because there's a fire, that's what we do. And you come and you put it out, is what you do. But the guy's still there and he says, well, I'm gonna start it again as soon as the fire truck leaves. So what we need is the police. Well, so where are the police on this?
My understanding is that typically when the CAP team responds and finds instances of illegal fires in illegal campsites, is that they issue citations for it.
They what?
So not much really. They don't care. Now it's fire starter. They don't.
Yeah.
Russ, you didn't stand up before, but are you wanting to get recognized now?
Yes, sir. I have a
Mr. Webb.
comment, that I would like to make in regard to this specific issue,
Yeah, sure.
if I may.
Come on.
So for the record, my name is Russ Webb. I would like to speak just briefly about this issue. On the 30th of December, my wife and I were walking along Chester Creek Trail as we do regularly. Just south of the football field across Chester Creek Trail, we smelled something that smelled like plastic burning. There was an encampment nearby, big 4-person tent with an auxiliary 2-person tent for storage. I walked into the area because it smelled like plastic. As I walked in, a woman opened the tent flap over the entryway, asked who I was and why I was there, and I explained I was concerned that there was plastic burning at the campsite. She said, no, nothing burning here. I looked, I could see inside her tent there was an open flame in the tent. I took a picture of the open flame, and I think we've distributed it to you. If not, we'll be happy to do so. Adjacent to the tent were 2 gas cans and a 5-pound propane tank. As you know, as we left the camp, we saw another common occurrence, which is a gentleman riding a bicycle with a jerry-rigged trailer carrying another 5-pound propane bottle to his camp. These things, it highlights several things for me. Ongoing dangers that are to the campers themselves, to municipal land, to the homes and residents in the area near the municipal land occupied by campers. This woman was in danger of asphyxiating herself. She had no vent for her tent. She had an open flame in the tent. I've been in cold weather hunting camps for many, many years, oftentimes months at a time, both in a base camp and a spike camp. So I know you have to have ventilation or you're going to be dead. The danger of a flash fire from an open burn inside a synthetic tent is significant. it can go up like that. And with accelerants like gasoline and a contained propane tank in the immediately adjacent to a burning tent, you're going to have a big fire.
Explosion.
And an explosion. That person would be dead, as well as oftentimes adjacent campers in the area. In the incident that my wife described to you earlier, in that area there are 6 other camps just in a wooded area from 16th Street to the Chester Creek Trail. There are 6 other camps. I know, I've been in each of them. I've taken pictures of each of them. I've reported each of them. Had the fire that we saw gotten out of control in that wooded area, they could have all been dead. The danger of the toxic smoke from the kinds of materials that get burned in these things is not insignificant, and I heard at one of our previous meetings on this that the fire department is often concerned about sending folks in because of that toxic smoke. The fire that we saw, the gentleman had a sleeping bag draped over 2 downed trees that were held by their root balls and other trees. They were dead. He had a sleeping bag hung over, apparently trying to dry it. While I was there talking to him about it, that sleeping bag went up in flames. And had it gone and caught the rest of those trees, all of which were, the dead ones they were on and the others around them, which are now dry, we would have had a serious fire. And maybe 6 dead campers in the area and the residences across the street from it could have gone up. The threats are real and they're significant. And I will tell you from my own personal experience from spending lots of time in winter hunting camps and from my personal experience in investigating virtually every camp on the Chester Creek Trail, every one of them has a heating source that's an open flame and a cooking source that's an open flame. And we're going to have dead campers. We're going to have wildfires in our public spaces, and we're potentially going to have fires affecting the surrounding areas, the residences, and the occupants of those residences. We cannot simply sit by and let it go. As has been indicated, the fire department, when we called in the one fire, they roll out a big rig. There were 4 firemen there. They put out the fire. As the gentleman said, he's going to start it right back up again as soon as they were gone. I don't know if he did or not.
Do you take the propane tanks, Chief,
No.
when you go?
No. We have no capacity or means to procure any of them.
And do you typically have APD there, or it's just you on a fire? If there's nothing else, would APD follow up?
If the camp has not been posted, we inform APD of the non-recognized camps, we let them know and post it. But if it has evidence that it's been posted, at that point, once the fire is out, we don't inform APD, unless in this case, the person who was there is aggressive and combative.
So is this a writing a different law or an enforcing the one we got? You read the section. Does that give you the fire protection enforcement that you need, or do we need to do something else?
It only gives us the power to extinguish the fire. We don't deal with the illegal camp per se, or any of the other gas cans, propane tanks.
Okay. Questions from the committee, Mr. Constant?
Yeah, I think that it's worth reiterating what the chief said, and I support this completely, that AFD does not take on any law enforcement at all, nor should they ever, because it protects them, it protects the community, keeps them from getting shot at when they come in. And so we want to ensure to maintain that level of difference between the two forces. They don't carry guns and bulletproof jackets, and so or vests. And we just need to be really cognizant that AFD does not do law enforcement.
Mr. Dunbar.
Thank you, Mr. Chair. So for the chief of police, then, if we're not going to have the firefighters taking the propane and the accelerant, I assume it's the policy now that the police don't take that or seize it. I thought we'd had this conversation when we were debating the last one, but I certainly would support a policy or a law, if necessary, that does just that. That we understand that there are certain constitutional and practical storage requirements that prevent us from taking a large amount of stuff out of the camps. But when it comes to accelerants and propane, it seems like it's a separate category that we could carve out and make it a policy to remove immediately, because they present a pretty clear and present community danger. Is that something that the police are capable of doing under the current law, or would it require legal change? And if it would require legal change, that's something you would support?
So a couple things in there. I think that as far as current law goes, I'm not sure that we could just immediately seize that stuff and walk off with it. I'm not sure what legal theory would allow us to do that, especially given the nature of taking stuff out of the camps and the current structure that is in place for us to deal with that. But if there were some kind of change that permitted that, I guess if it were an expectation that we seize it and store it for some period, we really don't have any capacity to do that. We can just barely keep up with the storing of actual criminal evidence. So storing anything that's not evidence for any length of time is simply something we just can't do right now. So if it were something that we could seize and immediately destroy, we maybe could do that, but I think that might be difficult to accomplish if it's something that has any reasonable value.
That's one
Yeah.
fault. Well, I mean, I think accelerant, you if you found some lighter fluid, I think that would be relatively easy to dispose of. Harder than some things, but relatively easy. I do think you're right that, like, if we were seizing a bunch of propane tanks, the destruction of propane tanks would be problematic. I think it would also cause a lot more propane tanks in Chris's neighborhood to get stolen. Yeah, or our neighborhood. So, yeah, I could see a challenge there.
If I could, sir, just believe it or not, actually disposing of that kind of stuff is very difficult because it's hazmat.
Right.
So what you might do maybe if you're disposing of it on your own property is different than when the government actually goes to dispose of it correctly by law. It's very, very expensive.
But the alternative, though, is to leave hazmat in our parks.
That actually brings up somebody who's sitting over there kind of quietly hiding, Mr. Rada's team and how they deal with them when they come upon them.
Well, are you still cleaning up, Mr. Rada?
Yes, we are. We just hit 172 tons for the year.
And
Yeah.
thank you, Mr. Chairman. So, when you guys clean out a camp, what do you do with the empty propane tanks, or do you pick those up, or
Yes, we have an agreement with Blue Rhino, and we take them. We do not handle them personally. We take them to the South Anchorage maintenance shop. We have a designated secure area. The tanks go there. Blue Rhino picks them up, removes them, and handles them appropriately.
So is that something that the police department could make a deal with them as well, so that, or the fire department if they confiscated some propane tanks? Is that a possibility?
I mean, we could look at something like that. I still think probably Chief LeBlanc would suggest that the fire department doesn't want to be involved in seizing any kind of property.
Okay.
But that's something that we could look at. But something like that we would have to have it in place, because right now we just don't really have the capacity to keep that stuff for any length of time,
Right.
and disposing of it's difficult. So it's great that they have a method for that, because that makes it a lot easier.
All right, thank you.
I just would quickly follow.
Yeah.
I think that in any way it's organized, I think it's smarter to have our parks folks do it than our police or fire, because when you're having your police do it, you are literally engaging the police power of government, and this is not the power you want to use, or at least you want to limit it as much as possible. And so wherever possible, the system we've set up is pretty reasonable and logical. We should figure out how to make that work as best as possible before we start creating a new level of police enforcement, if we can.
Before I got in the assembly, I represented Andy Mullen, who got cancer and died as a firefighter. And one of his first calls out, the guy was bicycling away after burning some wire to get the copper. But he was going to chase him down, and older firefighters had to say, "You're not doing that, rookie. That's not what you're out here to do. Mr. Steele?
Yeah, it does point out a bit of a problem, doesn't it? One is camping in the parks. We've just created a new ordinance, it gives them 10 days. How do you go and how do you keep the fire out? And the fire's in continuing danger for that 10-day period. It seems to me that we ought to be able to keep fire out of those green belts or public spaces unless they're in a designated space, unless they're in a campground or a picnic area in a closed container for those purposes. It just seems to me that putting a 10-day post up just says go ahead and break the law, go ahead and burn, and we've got to find a solution to that.
Well, what's the penalty, Ms. Thino, for burning in the park? Is it a violation, or can they be arrested for it? Do you know?
There's a criminal charge for burning of other people's property, negligent burning, and that, I believe, is a B misdemeanor. There are also some civil citations.
But just
But on
having it,
public property?
Mr. Croft, if I may, it's a $300 fine. That sounds right.
that's what I thought. I didn't think it was a jail punishable offense. All right, we will bring the, thank you for both all that.
If I respectfully can make one more comment, and that is this. We are talking about solutions that are behind the curve. Sending a big rig fire truck and 4 firemen out to put out a fire is incredibly expensive. Sending a police officer or a team out whenever you get a report is also incredibly expensive. We have to get ahead of the curve. We have to have somebody doing what I've been doing, which is going through the camps and identifying where they've got 6 or 8 propane bottles stacked next to their camp or accelerant
Or even what?
such as gasoline, or they have an open flame in the tent or whatever, and making sure that they're stopped every time.
Thank you, Mr. Webb. I propose to adjourn.
Last words. We proposed
You.
twice now to create the park superintendent team that would be actively showing up at parks, preventive team. Also let people out of gates at night and, let if they get locked into parks. And so that idea has been discussed, and we butt up against the limited resources of our city government at this time. But know that conversation is happening and has been proposed on how to get forward of that. So we might need some more
What
pressure.
about the
We
10-day
did
rule?
fill up the available time. This committee meeting's adjourned.